Good night, everyone. This is U.S. Immigration Attorney Tharpe. I am here live to take your U.S. immigration related questions. So go ahead and put your questions in the comments so that I may answer your questions. In the meantime, let me formally introduce myself. I'm U.S. Immigration Attorney Tharpe. I help clients to get their status and green card in the United States. I also come here every night at 9 p.m. Eastern Time to take your questions, and here I am today. I usually come with a topic to talk about, and so today I'm going to be talking about what if you're in the United States, you're without status here in the United States, and you cannot adjust status. Adjust status means you can't stay in the U.S. and apply. What options are available to you? I'm going to cover that topic tonight. But keep in mind that if you have a question that's not necessarily related to what I'm talking about, feel free to put your questions in the comments still, because my priority is your questions. And so I want to answer them. And also keep in mind, if you have that question, a ton of other individuals have the same questions. And so my answers to those questions can help me to provide information that you care about. So go ahead and put your questions in the comments. So how can you, if you cannot apply for adjustment of status in the United States, what are your options? Now, usually, here's the most common ways that you can't qualify for adjustment of status in the United States. And that means you can't stay in the U.S., apply for your work permit, and just wait on your green card process to be completed. So usually if you enter the United States, so you enter without permission. You entered without inspection. That means you didn't go through an officer. The officer didn't wave you in. Or the officer didn't review your documents, then in that case, you would not qualify for adjustment of status. Another thing is, if you even came into the country with a visa, but you overstayed, however, you're not the immediate relative of a U.S. citizen, you likely would not qualify for adjustment of status. There are exceptions to that rule, though, that I want to quickly touch on so that you understand. Now, under limited circumstances, individuals who are going through certain things can still stay and adjust status, even if they came into the country without permission, even if they're not the immediate relative of a U.S. citizen, but rather they may be the son or daughter of a green card holder, or they may be the parent of a U.S. citizen 21 and up. Now, this is through VAWA. So if you're being mistreated by a U.S. citizen or legal permanent resident, spouse or parent in the United States, hi there, Charming Rose. It's always nice to see you. And thanks so much for those of you who are joining in that always come to support my lives. I really appreciate you being here. So what is the I-130? The I-130 is that petition. So it's a petition for a relative. They said they're going to get rid of the alien, which they should. So it is a petition for your relative. That relative, so it means that whoever is filing the petition qualifies to apply for their relative who is either here in the U.S. or they're in another country. So usually those who can file this petition are going to be the parents of the U.S. citizen children, adult children. So adult U.S. citizen children, so 21 and up for their parents. Spouses of U.S. citizens, spouses of green card holders. Now, let me rephrase that just so that you can understand. So those who are going to file the petition are those who sponsor their relatives. So those who are going to file the petitions are going to be U.S. citizens for their spouses, U.S. residents for their spouses. It's going to be U.S. citizen siblings for their siblings, green card holders for their children, and U.S. citizens for their parents. So those are individuals who can file the I-130 petition for their relatives to get the permanent residence or green card. How long does it take for the I-130? Chanel, is going to depend on how you're filing. Some processes take priority and some take longer than others. So it depends on who is applying for you. Who is applying for you? What's their status? What's your age? Where are you? And then I could better answer that question, because there are so many different time frames. Babe 1900, I have upcoming interview for F4. My mother's name is spelled wrong on my sister's birth certificate. So congratulations on your upcoming interview. In this case, if your sister is the one who is petitioning, then she has to provide some sort of explanation, or even if she can provide a corrected birth certificate, that would definitely be ideal. However, the circumstances around the incorrect name and how severe the incorrect name is going to be is going to depend on your particular circumstances, and that's where you will need to schedule a consultation to talk about how to approach it. So Candy Marina, thanks for the rose, I appreciate it. So how long for brother to file for me? He is 24, I'm married with children, I'm in Barbados. So Toyat 85, it's taking about 14 years right now, at minimum 14 years. And now after that's the downside. It takes very long, and so you do have to be invested, you do have to wait. But once you get through the process, you can bring your spouse with you, and you can just make sure that they're included in the application, and any children under 21 and unmarried. So how does the sponsorship go? So Queen Sheba, if you have a relative, a qualifying relative, that's going to be a U.S. citizen or legal permanent resident parent. It's going to be a U.S. citizen son or daughter 21 and up. It's going to be a U.S. citizen sibling 21 and up. So if you have qualifying relatives like those, or even an employer who is willing to apply petition for you to get permanent residence, then that is what the sponsorship is. You would submit the relevant forms and documents in order to get permanent residence. I did file I-601A, still pending. Can I file I-601? So Mike Chicago, it's going to, if you have another issue that's pending, then you will need legal advice, because then things are getting a little more complex. The I-601A is only for those who are here and have accrued unlawful presence. That means you overstayed over 180 days and you're trying to get forgiveness for any consequences that will occur as a result of that overstay. However, when you want to file the I-601, that means that there are other inadmissibilities, and that it depends on what type of inadmissibility you have, what's the basis. In some cases, that does require you to first go to the interview and get confirmation that you require an I-601 before you can file. Because with other inadmissibilities, so the I-601A, you can file it before you even go to the interview at the embassy abroad. However, if you're filing for another type of waiver, assuming you qualify for it, usually one of the requirements is that you have to attend the interview and the officer has to confirm. So when you're filing it, you have to provide evidence that the officer has already confirmed you qualify for a waiver. My mother sponsored me. Zinab, how long will it take? So if your mother sponsored you, if you're under 21, you're looking at 18 to 24 months. If you're over 21 and she's a U.S. citizen and you're unmarried, 6 to 7 years. If you're married, she's a U.S. citizen, that's taking 12 years. If you're unmarried, she's a green card holder, which you have to be unmarried for your green card holder parent to apply for you, then 5 to 6 years. And keep in mind, these are based on the information that I review on the National Visa Bulletin, but it's subject to change just because it depends on how many applications are being submitted and whether how much more applications there are compared to the available immigrant visa numbers. How long is the process for a fiance visa application? I filed for my fiance 5 months ago, so you could be looking for a little over a year for that. So it's right now those are taking over a year. I'm getting married to a U.S. Citizen in November. How long can I apply for my 20-year-old son to come to the U.S.? So if your son, so you would have to become a permanent resident. So Raisa, you'd have to become a permanent resident before you file for your son. So once you become a permanent resident, then you can file for your son. Talk 1981, thanks for sharing the live. Michelle Stevens, thanks for sharing the live. Trini, Bev Girl, good evening. How much for the consultation? So my consultation is up to is $150 for up to an hour. I like to follow this with it is worth the money, because you walk out of the consultation knowing exactly what you qualify for, how to approach your situation, whether there are other options available. You avoid mistakes. And let me tell you, mistakes can go from being fairly simple to being very complex, especially when you don't get the legal advice you need and you go knee deep or neck deep into the process before and make a devastating mistake, which then costs more money to fix. So to schedule a consultation, you can do that by going to the link in my bio, going to the website where you'll get all the contact information. You can call, do online chat, or you can fill out the contact form and a scheduling coordinator will get you on my calendar to talk more. So let's see. Raisa, you're welcome. So I'm not married legally, but I have 2 kids. So Sinab, if you have 2 kids, the good news is that if your mother sponsored you and you're over 21, so as long as you're not the immediate relative of a U.S. citizen, that means you're not under 21 and unmarried, you could bring your children along with you as long as they are under 21 and unmarried. You're welcome, Raisa. Queen Sheba, I have a friend who's illegal, but her undertake job boss wants to sponsor her. So that's where her boss is definitely going to have to schedule a consultation, because whether or not that's an option is going to depend on the needs of the boss, whether the boss is willing to go through the processes required, which includes a labor certification. It's going to also depend on the needs of her qualifications and even the needs of the country. So very important that the boss schedules a consultation. If the boss wants to sponsor her, they should definitely look into that, and they can schedule a consultation with me to determine the options there. If you're a parent filing for an adult child from 2012, but he's here, USA Now Center says he needs to go back to Jamaica, is there a way he can stay and get through? So now I don't know his age. It just depends on his circumstances. One thing Tug 1981, I never say on here that there's no hope until I actually get to sit down with the individual to talk about their circumstances, because there might be something that happened in their background that could qualify them. So for example, I've had situations where I have consulted with my clients who turn out that they've been trafficked into the United States and they didn't realize that what happened to them was trafficking. Sometimes they've been the victims of a crime and they didn't realize that they could get a visa to stay in the United States and eventually become a permanent resident through the U visa. Now, in this case, if he's over 21 and he is out of status, then he would have to go through the waiver process. That's the next best thing here. And the waiver process allows him to, and that's of course as long as he entered, and unlawful presence is his only immigration violation. Now with the waiver, he can stay in the U.S., apply for the waiver, and then all being well, he gets a if he gets a decision, an approval on that waiver, it would allow him to attend the interview in Jamaica and not face the consequences of, so they would not use the overstay against him. But to evaluate whether he qualifies for that, I would definitely have to, he would definitely have to schedule a consultation and let me go through his full circumstances. While waiting for an I-130, can't travel. So in some cases, travel is not recommended, just because if you do travel, you could be turned around if they feel like you are at risk for staying in the United States, based on that immigrant intent, which is based on that I-130. The I-130 means that you're being sponsored for permanent residence, which means that you intend to live in the United States in the future. Hi there, I've overstayed my visa and had a kid besides getting married. What else are my options? So it depends on your circumstances, Liam Cupcake. Do you have, even though you don't have a spouse, do you have a U.S. citizen or legal permanent resident parent? A waiver might be an option. If you have other circumstances in your background, that could possibly be a path. But before I could answer your question about what are my options, I would definitely have to talk to you in a consultation, because the information I'm giving you is very general, and so it could take me hours to talk about all the different immigration options. And so it's that's what I do when I come on in 30-minute increments, is I talk about one topic. However, one topic at a time. However, in this case where you're trying to figure out all your options, that's where you need to schedule a consultation. You can go to the link in my bio, go to the website, and you can call. The scheduling coordinator is available up until 11 p.m. tonight. So Queen Sheba, thank you. I hope you do. Does no RFE mean the case has high chances of approval? Not necessarily, Varun, and it depends on the case that you're talking about. Hi, husband had his interview yesterday. How long before a response from the interview in South Carolina? Sassy Move, I hope everything went well at the interview, and it really depends on what the officer said. So did the officer hint that you would get an approval? Did the officer hint that they wanted to review your records more extensively, or they had to pass it on to a supervisor? So it's going to depend. I've seen decisions come in 2 weeks, and unfortunately I've seen decisions on hold for a year or two. So it just depends on what the facts are in your circumstances. If there's something that you're concerned about, definitely give me a call, schedule a consultation. Latoya Pass, thanks so much for sharing the live. I appreciate that. Liam Cupcake, no parents. Okay, so Liam Cupcake, maybe the waiver would not be an option for you, but I don't like to say here you have no options. It's always best to schedule a consultation, because you never know. I don't know your situation, I don't know your facts, and I'm not your attorney, and so I wouldn't be able to provide you personal legal advice until we're in that consultation. If your spouse has a felony, can you apply for your own green card? So not necessarily. It depends, Boss Lady Pelt, on so there is no process in place if your spouse has a felony and is unable to apply for you. However, if your spouse is mistreating you, and when I say mistreating you, it could be not necessarily, it doesn't have to involve physical violence. It could mean verbally, mentally, emotionally, financially. If this situation is happening, then you could apply for your permanent residence on your own and get your work permit, stay in the U.S. And it doesn't matter if you're married or not. And so whether you qualify for that is going to depend on your particular circumstances and the circumstances surrounding your marriage, and even that felony charge, if that's relevant. So if, for example, your spouse has a felony because they committed domestic violence against you, that would definitely qualify you to apply for your own permanent residence. So as you can see, it's going to depend on what's going on in your marriage. What I can say, Boss Lady Pelt 36, call, schedule a consultation. Let's go through your circumstances and confirm whether you qualify for this form of relief. You're welcome, Liam Cupcake. Can green card be renewed despite the citizenship being denied? So that is going to be a complex question. It really depends on why your citizenship was denied. It is possible to get it renewed because in some cases you are not necessarily deportable, or it doesn't mean that your green card is going to be revoked. It just means that you don't qualify for the citizenship. But what is the basis of the denial? Was it something based on a crime that could render you deportable? In the case that it does, then it could prevent you from getting your new green card. And that's where Wally the King, you need to schedule a consultation and get legal advice. Because when it comes on to citizenship denials, it can get complex, but it's very important for you to get legal advice, because then you can determine your options for the future. So no RFE only means that initial review seemed everything was fine. So Varun, I don't know what type of application you submitted, and so I wouldn't be able to confirm that until you tell me what kind of application you're filing for. Now, when you don't see an RFE, it doesn't mean that it doesn't mean anything really. It just means that you have to sit tight for a decision. Officer gave the indication of reviewing with the supervisor. She may do an RFE. So in that case, Sassy Move, you want to just pay close attention because there may be some additional questions that officer has. And so you have to be on high alert here because once they start to get into, they have to have the supervisor review it, and they may send you an RFE. Then that could definitely mean that they're not, if this is a marriage base, that they're not convinced, or something is, they have additional questions. So if you are concerned about your situation, so they may issue a request for evidence. They may even issue a notice of intent to deny, which I hope they don't. The request for evidence is of course the best, the better than the notice of intent to deny. But in that case, make sure that you get legal advice. Make sure you're covered, you're prepared for what may be coming. Jerome Pert, waiting on interview date from National Visa Center. Why taking so long? Everything is backlogged, unfortunately, and COVID has made it worse. My husband wants to file, but has not started yet. Is it okay to try to apply for my visa to visit him? So yes, you can always apply for your visa. You just have to make sure that when you do, you're totally honest and transparent with the officer so that they don't tag you for any fraud or misrepresentation when you're trying to get the visa. This may also mean that if the officer identifies that you have a spouse here and that you are at risk for staying in the U.S., they could very well deny your visa and just tell you to have your husband file for you. So you could try, make sure you show strong ties to show that you do intend to return to your country after a temporary visit. Any idea what the RFE was or will be about? So that is a good question. Hi, Dark Horse 45. It's always nice to see you here. Thanks so much for joining in. So Varun Malhotra, it's adjustment of status. So if it's adjustment of status, no RFE, just means that you should wait for the interview. And it's really at the interview that you're going to get a feel for what is to come. You are welcome, Boss Lady Pelt. You're so very welcome, and I'm here to help. So if you are going through an issue with your spouse, definitely call, schedule a consultation. Even if you're not, I want to help you to evaluate your situation. How difficult is it to prove extreme hardship for an American citizen spouse? So it depends on what your circumstances are. It really is not a matter of how difficult it is. If there are extreme hardships, you will be able to prove it. So it's a matter of getting the help you need to tailor the story for the officer to understand how severe those hardships will be and to support that those hardships. So the question is what is happening to you right now considered an extreme hardship? Now, how I like to explain it is, if you are basing the extreme hardship is based on the spouses, the citizen spouses, extreme on the situation, and so if you don't get the green card, what kind of devastating consequences will follow? Sometimes showing that will be based on the type of hardship. For example, if your citizen spouse has a medical condition, it's a matter of getting a doctor's letter, getting the medical records together. If it's about the crime that the spouse will have to face in the country, if they have to relocate with you, then it's about putting country reports together to show how severe the crime is and that U.S. citizens are often targets of those crimes. So it depends on what's going on in your situation and whether that amounts to extreme hardship. So AOS through marriage. So right, Varun, where usually the test is going to be at the interview. So if you go to the interview and the officer is going to ask you questions, that is where the officer is really going to make their decision. Do you suggest spouses of undocumented immigrants to have a joint bank account to prove valid marriage? That's definitely a good idea. I definitely don't suggest that you just go and put a joint bank account together just for the marriage sake, because the officer can often identify that you did just that. If you have a joint bank account where the both of you are active on the account, the expenses are coming out of the account from both you and your spouse. Is showing paychecks, the both of you are depositing money into the account, the both of you are writing checks on the account. That is what the officer will look at. So they want not just the cover sheet of your joint bank statement, they're probably going to want to see all the activities on your bank account to really be convinced that this is evidence of your bona fide marriage. Now, if you can do that, definitely that is a good idea to have your joint bank account. That's one of the pieces of evidence that they often like to see. Sassy Move, we provided additional pics, updated bank statements, and joint bills. So Sassy Move, it could very well be that you could get an approval. So just hang tight. I'm going to keep my fingers crossed that it's not going to lead to any more delays or any more issues, and that you will have smooth sailing after you get an approval. So let's hope for that. But Sassy Move, if you are concerned about anything, you can call, schedule a consultation, and we can talk about your particular situation. So how long takes joint motion for give? So I think the joint motion is where your attorney files with the opposing counsel, and that's going to really depend on the attorney. So if you're working with an attorney, you should definitely direct that question to your attorney who is currently working on your case. If that is something that you want to explore as an option, definitely give me a call, schedule a consultation. Can persons remain legally in the U.S. while being filed for? Yes. So if you are on a work visa, for example, and then your relative starts to file for you, that may be a way for you to adjust status and not necessarily have to go back home. But it depends. It depends on your visa. It depends on how long that visa can last while the process is pending. So for example, if your visa is going to last 6 years and your relative has started a petition for you, but this petition is going to take 14 years, then you will have to figure out a way to continue having status in the US in order to adjust status, which would be hard to do. So very important that you get legal advice to figure out your options going forward. What do I need for my daughter? She's 14, trying to apply for a visa for the US. So your 14-year-old still has to show that she will return after a temporary visit to the US. So she will have to show her strong ties, and that means showing strong ties through her parents. So parents, the parents' resources, and so forth. Fiona Garrett's, is only by marriage can you get your green card? Absolutely not. An employer, you can get it through a U.S. citizen, through other types of family members. So through a parent, U.S. citizen parent, through a U.S. citizen child, 21 and up. There are other ways as well if you want to file for asylum and you qualify for asylum. Of course, asylum means that you have a fear of returning to your country because of persecution. So Boss Lady Pell, definitely I'm looking forward to speaking with you and advising you and helping you through all being well and you qualify. Is only so let's see, can you get a visa without getting married if you overstay your visa? That depends. It depends on your circumstances. So there are different ways, but it depends on what you've been through. Have you been the victim of a crime? Have you been trafficked into the US? Do you have other relatives? Do you have a US citizen or legal permanent resident parent who could possibly apply for you and help you to qualify for a waiver? So that is where you should definitely schedule a consultation to evaluate what your options could be. What happens if your spouse doesn't show for your green card interview? So positive messages 17. There are a number of reasons that could happen. I have clients where that has happened to them, where the spouse intentionally tries to sabotage their green card process because they don't want them to get the green card. It could be you are being mistreated in the relationship, and they decided not to follow through with the green card process because it's a control issue, or they're just being plain cruel. So in a case like that, there is a way to move from the adjustment of status process, still maintain adjustment of status, but submit an additional application based on VAWA, based on the mistreatment. But in order to qualify, of course, you have to show that there is some sort of pattern of mistreatment in your marriage, and that's going to be, it can be verbal, emotional, financial abuse, or mistreatment, or extreme cruelty. It could involve abandonment. So if your spouse didn't show up intentionally, then that could amount to cruelty, the fact that they're keeping you from getting your status. Can one renew their visa while in the US if they are not a citizen? So usually to renew the visa, you will have to go back. If you're applying for an extension to stay a little longer, that is something that's permissible. Whether or not you get approved is another story. However, renewing your whole visa is usually you have to go back to your country. Thanks so much for the love. My U.S. citizen's daughter have asthma patients, have severe asthma. Patients have chance to go with joint motion to get approval. So I'm not sure if you are applying for deferred action or something of that nature. But Surgery, that is where you definitely should schedule a consultation if you don't already have an attorney, because your situation is a little more complex. Chanel Lewis, can a green card holder apply for husband? Chanel Lewis, absolutely. A green card holder can, and right now is a good time to, because they have no wait list right now for an immigrant visa number, which takes the longest to get. That's what makes the process longer. So green card holders can apply for their spouse. Now, the type of process you will pursue depends on where's your spouse. Are they in the U.S. or are they outside of the U.S.? That's where it's very important to get a consultation. So positive messages, so your internet stopped. What happens if your spouse doesn't show up for the interview? So if your spouse intentionally missed the interview to sabotage your process, that could be a form of abuse. And I would like to explore that more to see if you would qualify to apply for permanent residence for a work permit on your own. And so that's where positive messages 17 is important to get legal advice about your rights. So you can go to the link in my bio, go to the website where you'll see the phone number. There's a scheduling coordinator who's available up until 11 p.m. tonight to take your call and schedule your consultation. So my husband have green card and my papers in. How long do I have to wait to get a work permit? So Sexy Girl 1980, if you are currently out of status, keep in mind that adjustment of status for you may not be an option. So you need to get legal advice to make sure that you fully understand the process that you're following and that you qualify for it. Because if you are not, you may get a nasty surprise at the end. And so it's very important for you to understand. If you're outside of the US, then not so much. You'll have to wait outside of the US. That process is taking about 18 to 24 months. But if you are in the US and you are out of status or you're about to be out of status, you need to get legal advice. Did my biometrics August 13. How long you think I'll hear from the USCIS? So I would not be able to tell you that. It really is on a case-by-case basis right now. So stepmother is citizen and dad is green card holder. Can they invite their sons for Thanksgiving? So it's really, they can invite definitely, but whether the sons can apply for a visa is really going to depend on whether they qualify at the U.S. Embassy. They will still have to independently apply, of course, indicating that the reason for their trip is to visit their parent and step-parent. But applying for the visa is another thing. Will the code say anything about the parent name wrong on the? So it may definitely be an issue. Definitely, it really depends on how severe is the error and so forth. So, babe 1900, schedule a consultation and your interview is Friday. So if you can't get it corrected at this point, you should definitely go in with an explanation if the officer asks an explanation about why it is wrong, and if the officer has any questions, they'll definitely direct you on what to do next. All right, so I'm going to head over to Instagram. I do a live on Instagram at 9:30 every night as well. So our conversation does not have to end here. All you have to do is hop on over to Instagram. You can go to the link in my bio where you can see the Instagram button. Hop on over there. And so my sister was approved of VAWA after she received a letter saying they will approve her for adjustment of status. So congratulations. Can I take explanation, or do I have to show a document? So babe 1900, I cannot advise you specifically. I'm not your attorney. I haven't looked at the records. I don't know your situation. And so at this point, you will have to get legal advice in a personal consultation for me to advise further. So I am located, Raisa, I'm located in Boca Raton, Florida, but keep in mind, as a U.S. immigration attorney, I represent clients all over the country and the world. And so I'm not limited by borders or state lines. If you have a U.S. immigration issue, I can help. So you can definitely call, schedule a consultation. Z35ZQ, you are welcome. So thanks everyone for your questions. You can join me to continue this conversation on Instagram. I'll be there in a minute. If I talk to you and you know that you'll need a consultation, Raisa, you're welcome. Go ahead and call the number. It's all over my videos, the phone number, or you can go to the website where you are welcome. where you can go to the website. There's the phone number, there's online chat, there's a contact form. Any one of those will lead you to a scheduling coordinator who will then schedule the consultation. The consultation is $150 for up to an hour, where I give you legal advice. I talk about your options. I talk about how to approach your situation. I help you to avoid mistakes, which can turn into much more expensive mistakes. So it is worth your time and money. And best of all, you can walk out with me as your attorney to help you through the process if necessary. Question, what if I was filing on before I was 18 and it came through after 21? It's going to depend on, hi there, Dark Horse. It's really going to depend on who's filing for you, your fave company. So you need to schedule a consultation, and I can advise you specifically. Heading over to Instagram now. I've told you how to get in touch with me. If you want to join me to continue this conversation, hop on over to Instagram. I'm going to be there in a minute. All right. So I'll see you tomorrow. If you can't join me on Instagram, I'll see you tomorrow at 9 p.m. Eastern. Have a good night, everyone, if I don't see you on Instagram.